November last year, the government adopted a long-awaited National Security and Investment Bill. And this bill heralds the introduction of the most far-reaching changes in the treatment of mergers and acquisitions in the UK in several decades. And since November, the passage of the bill through the House of Commons has been relatively swift. In fact, the third reading is taking place today, and so far there have been no amendments to the bill. There's no indication of the likely date of the royal assent. It's clearly got to go through the House of Lords, but my sense is that there's no reason in principle why this bill couldn't enter into force in the next few months. Now, at present, as you probably know, the UK has no separate foreign investment regime. There are some provisions in the merger control regime. They've been relatively little used, in about 20 cases, in fact, although there have been some cases of political intervention outside the former regime. And the bill has two main elements. The first is the introduction of mandatory prior notification and approval of acquisitions of rights or interests, which you can refer to broadly as control, with a very low control threshold, in qualifying entities. And these are entities effectively carrying on business in the UK or supplying goods or services to customers in the UK. And for the notification obligation to arise, the entity must be active in a sensitive sector. And we'll come to what that is, but it includes energy and specifically oil and gas or aspects of it. Now, the second main element of the bill is the possibility of retrospective review of acquisitions for up to 5 years after the event. The risk of such an investigation can be mitigated by voluntary notification. And there's even a possibility of retroactive validation. Now, there's some detailed guidance on the application of this regime to the oil and gas sector. That, along with other sectors, has been the subject of a consultation that concluded on the 6th of January. Nothing's yet been published by the government on the effects, but my sense is that the overriding issues that have caused energy and oil and gas to be included in the list of sensitive sectors, along with a lot of advanced technologies and other things that could be relevant to the sector, is not going to change. So we'll be talking probably about definitions and clarifications against the background of the fact that the government hasn't defined what national security is, deliberately in order to keep room for manoeuvre as things change. Now, I'm going to talk a little bit more in detail about the provisions of the legislation. Jason is then going to talk about the this notion of sensitive sectors, with the benefit of insight into how the US government has handled these kind of issues for many years under CFIUS, which you'd be familiar with. Then we have a series of case studies which are designed to highlight a few of the issues. And we've included a slide with some practical issues which really go to transaction planning. It's worth saying that this is not to be seen in isolation. As you'll be aware, a number of countries have for a very long time had some national security or foreign investment legislation. What has happened in recent years is there's been a combination of geopolitical considerations and technological change, heightened security issues generally, and the whole area is burgeoning. There are quite a few new regimes rather like this. This is probably, I would say, at the high water mark. It's not the most draconian, but it's up there with the most draconian. The mandatory notification obligations backed by criminal penalties, companies and individuals, as well as nullity of transactions. So that's potentially quite far-reaching. So, as I say, let's look a little bit more in detail at the mandatory notification obligation. The first point is, other than this notion of a qualifying entity, which I have referred to, the first point really is the trigger events. Now, the significant thing here is the low level at which they start. So you could have a mandatory notification obligation with an acquisition of an interest of 15% of the shares or voting rights in a company. Now, that's very new for the UK. You'll be familiar with that perhaps in Germany, when there's a similarly low threshold in some circumstances anyway. And then there are these successive thresholds listed on the slide of 25%, 50% or 75%. So each time you cross one of those thresholds, you could have to notify. So the same entity or the creeping acquisition of control could be subject to several notifications over time. Importantly, also, it covers the power to secure or prevent the passage of any class of resolution governing the affairs of the entity. And it's not entirely clear to me yet what that relates to. You might be familiar from merger control with the concept of normal minority protection. So a passive investor might be able to block a resolution, but it might only be to change the auditors. So the legislation itself isn't terribly clear, and I think there'll have to be more guidance on that. So the first point is the breadth of the control test. It does, as you'd expect, apply to joint and indirect acquisitions of control. And there's some fairly technical material in the schedule to the bill about joint entities, arrangements, connected persons. And again, that's very far-reaching, and with certain corporate structures, that might involve a lot of work. Now, as I said, the second main limb of the legislation is the call-in power, so-called. Now, this ability is again quite far-reaching. Under merger control, it's 4 months. After this is 5 years. Now, where does it apply? It applies to acquisitions of rights or interests in entities that fall outside the sensitive sector. So they're not subject to the mandatory filing obligation, but they can still be investigated. So if you're not on the long list that Jason's going to talk about, you still have to think about this. Secondly, it will apply to assets. Again, a distinction from UK merger control, although in America, for example, asset acquisitions can be caught. A striking feature of this is the breadth of what an asset is. As you'd expect, it can include land, movable assets, and the like, but it could also include an idea. So that again, in certainly the high-tech sector with intellectual property involved, is very broad. Now, the other additional limb to this is material influence. That again is lifted straight out of merger control, at least as a concept. And so we're very familiar with that. The people who wrote the legislation within BEIS, the relevant government department, were alive to the fact that it's not really appropriate to make a mandatory filing obligation conditional on something that's as subjective or fluid as material influence. There was one case a long time ago in merger control where 15% plus the personality of an individual on the board was enough to create material influence. So again, very low threshold. There'll be a voluntary notification procedure, which means that legal certainty may be available, where otherwise you'd be left with this sort of Damocles hanging over you for 5 years. And the government is encouraging people to go and consult early. I think what they don't want is a lot of precautionary notifications which will bury the system. There has to be, before the Act comes into force, a draft statement of policy intent, and that draft is available. It talks in terms of 3 types of risk. The target risk, so is this a sensitive target business, is involved in perhaps technology activities which we don't want to go to certain jurisdictions. The trigger event risk, I've been talking about the trigger event, and then the acquirer risk, which is more about the identity or the origin of the acquirer. It doesn't mean it's necessarily going to be certain jurisdictions. It could be just that offshore jurisdictions often have very opaque structures. There's been talk about hostile actors. It's not really confined to that. It could even be a UK acquirer. So that's really the core of it in terms of the legislation. There's one practical point to mention, which is that the call-in power actually already is potentially going to create transaction risks now for transactions that were entered into after the publication date. So that means that when the law comes into force, the government will be able to look back for the next 6 months at transactions that have just been concluded. So if you happen to negotiate your transaction before the 11th of November and didn't think about the allocation of the risk of an investigation, there could be some risk there. The government is saying we don't expect to investigate many cases, but I think this is partly precaution, and there's been a lot of concern raised about it. The government's expecting a lot of transactions to be notified. It's not entirely clear where these numbers come from. If it's anything like that, it could pose a severe administrative issue for the government. Competition law will continue to apply, obviously, alongside this. This new regime will take precedence if there's a conflict. I think what will happen is the government will work, or the BEIS team in the new unit at BEIS will work with the Competition and Markets Authority quite closely, and might even use its mergers intelligence unit to help gather information on transactions. Implementation, as I've mentioned, there'll be a new unit within BEIS. It's encouraging consultation. Now, the process I've just alluded to, there's not much more to say at the moment. There are a couple of committees still looking at the law, and we're waiting for the outcome of the consultation, which will be particularly relevant when we see what they have to say on oil and gas. So a number of points were raised in the House of Commons scrutiny. There were 12 meetings of the Public Bill Committee. Some were tabled, all of them were withdrawn or dropped. The kind of issues people have raised are, as I say, absence of a definition of national security. There are no thresholds, that's deliberate. I've mentioned a few of these. There's an issue about the role and accountability of the Secretary of State. Will he have the ability to do this? There's no track record, brand new team. Potential chilling effect of investment decisions, well, that's speculative. And the risk that at some point a government decides to use this legislative framework for different objectives, such as industrial policy concerns. That isn't the stated intent at the moment, but it's a possibility. So I'm going to hand over now to Jason to talk a bit about the sensitive sectors.
Okay, thank you, David. So just what is national security? I mean, this is really the key question, the critical question, both in terms of what sorts of measures the government might place to conditions on transactions, or whether it might block a transaction, but also what national security is going to weigh very heavily on whether parties file for review, both because they may fall within a mandatory sector, which we'll get to in a moment, or whether they make a strategic decision to take advantage of this legal certainty, as David said, this sort of safe harbor. You'll be familiar, those of you who have done any transactions in the United States that have been subject to CFIUS review, that much as in the new UK bill, CFIUS offers there's an opportunity essentially to have your transaction not approved, but for CFIUS to choose not to take any action, which provides you a safe harbor from later unwinding or amendment to the transaction. Parties will obviously be considering what would the government's national security concerns be about our transaction, and ought we file, even if technically speaking we believe we fall outside of the mandatory filing requirement. A good clue as to what the government is going to consider to be of importance to national security is on the list that you see in front of you. This is a list of sensitive sectors that the government has put out for consultation. You'll see that many of these are dependent on sensitive technologies, emerging technologies, or critical infrastructure. Some you might say are more based potentially on economic impact, but tend to be sensitive technology and critical infrastructure. I borrow that terminology from the laws that are underpinning CFIUS because of the similarity between the types of transactions that are subject to mandatory review now in the United States to the types of transactions that appear likely to be subject to mandatory review in the UK after the bill comes into effect. They're quite similar. So it might be worth saying on that another point on the safe harbor provision, and the government being overwhelmed by filings. The descriptions in the consultation of these sectors, some of them are quite specific, some of them are less specific. But because of the option for voluntary filing, if the US experiences any indication of how it will go in the UK, parties will make quite a lot of precautionary filings probably, and that may lead to some difference of approach later by the government if they see that it's just too much. And that's what's happening in the United States. So now there are pre-filing filings that can be made in some situations in order to kind of alleviate the burden on CFIUS member agencies. And before we go on talking about CFIUS member agencies, I might mention that David talked about BEIS and its coordinating and leading role in this. The much like in the United States, the reviews that will happen here will be kind of cross-agency, and whilst just as Treasury does in the United States, BEIS will play a coordinating role. There will obviously be kind of heavy hitters amongst the member agencies or the contributing agencies in a review of a transaction. So in the United States, it tends to be the Department of Defense and the State Department that are probably weigh the heaviest on transactions, which makes sense. Again, sensitive technologies and national security. So you have defense and you have the diplomatic arm. And here I think we would expect too that the MOD and the Foreign Commonwealth and the Development Office, as well as perhaps the Department of International Trade, will weigh quite heavily and be the sort of agencies that the parties will have in mind when they are assessing what would the government's concerns be. So looking at this list, obviously you see energy. That's quite important for this audience. You'll see how this manifests itself in the consultation, the description. So there's some specificity to the category here. You can see there are some technical parameters that's quite useful. Some of them are more exacting than others. I guess what I would say is that this, it is very, as you could say, very infrastructure heavy, not much in the way of information about sensitive technologies. But what we haven't shown you here are some of the other categories that could very well be germane to an oil and gas transaction, right? So it could be advanced materials, communications, encryption, robotics, AI, computing, whatever it is. All of those sorts of technologies, if those were to be relevant to a transaction, even if these parameters weren't met, the mandatory filing requirement could still apply. And where there is uncertainty, I think we would expect, again, borrowing from the US experience, that parties would probably, at least in an early stage, err on the side of trying to take advantage of that offer of safe harbor in the law. So the next slide, which these slides will be made available to you, is just more from the description of the categories that pertain more specifically to oil and gas. And on the slide after this one, we have some examples of transactions that have been subject to foreign direct investment review in other jurisdictions. The best known example is the China National Offshore Oil Company and their attempted acquisition of Unocal. It was CNOOC and Chevron were bidding for Unocal. This is an old case now, and CFIUS has changed quite a bit before then. There were sort of outcry from various members of Congress over the transaction, citing concerns about national security and about sensitive technology. I don't mean to say this in any sort of cynical way, but once the dust cleared, what happened was that Chevron purchased Unocal, and CNOOC went away, even though the CNOOC bid was higher. It was pretty well. I mean, the commentary sort of after the fact pretty much determined that national security, critical infrastructure, sensitive technologies weren't really particularly at issue in this particular transaction. I mean, Unocal's oil and gas assets were in sort of East Asia for the most part anyway, and there was unlikely to be an effect. And the technology that Unocal possessed was pretty well available everywhere anyway. In retrospect, it looks like it was more or less entirely motivated by economic interests. And I suppose maybe the lesson there is that even though this bill is primarily about national security, there's certainly a heavy, a sort of potential influence, maybe more than potential influence of economic interests that's going to play a role here as well.
Right. So thanks, Jason. Well, we now have 3 brief case studies, which are just designed to try to point up a few of the elements that we've mentioned. So the first one, I'll just go through the facts. The first one concerns a UK company, could be another company, but it's a UK company with significant North Sea oil and gas producing assets. And that's going to be sold. It might take the form of an asset sale, or it might be the company. And there could be different buyers. The buyer could be, for example, an international oil company, or it might be, say, a Bermuda entity. Now, the first point really is there a qualifying entity? Is there an entity at all? So if this is a pure asset purchase, it may well be outside the mandatory filing requirements. And that could be relevant if, for example, what's at stake is a participation in a contractual arrangement, such as a joint operating agreement. or it might be that there's some interest in or ownership of a license. So we may not be dealing with a business, but equally we may on these facts be dealing with a business. Now, is there a sensitive sector? Well, ultimately, I think it's best to look at the guidance in relation to materiality. I think the government is clearly concerned about security of supply. It's concerned about keeping the lights on and the heating on. And how far does that go? Well, there may well be certain activities that are, for example, offshore in sectors where there's a lot of supply and nobody's terribly concerned. But there'll be other assets, such as a critical pipeline, a terminal, storage facilities, jetties, all those kind of things, where there could be bottlenecks and ownership could be very important. Anyway, we're talking about North Sea oil and gas producing assets. So it may be that, depending what comes out of the consultation again, that we're not terribly concerned about that, but you may be left with some uncertainty whether there's a mandatory filing obligation, in which case the route would be to consult with BEIS early on and factor that into the transaction planning. That's the first issue. So there's one other point we put in there, which is this Bermudan entity. So this may not be that the acquirer is deemed to be from a hostile state. It may be just to know who is behind the Bermudan company. Thanks. Now, in the next slide, we have an interconnector involved, the large Bacton to Zeebrugge interconnector, jointly owned by two publicly listed companies. Let's assume that Flux, one of the shareholders, agreed on the 15th of November to sell its stake to a UK buyer, or that Flux is the subject then of a takeover bid by another company. So interconnectors are included in the list of sensitive sectors. That much is clear. The transaction risk that I mentioned before is potentially relevant here because this is happening before the commencement date of the legislation. It's relevant to note that this doesn't just apply to foreign buyers. The notification obligation can apply to a UK buyer. That's point A. I've mentioned previously this notion of joint interest, and here we do have potentially joint interest, although 24% may not be enough to allow them to block a resolution. There is, as I say, some quite detailed comment on what a joint arrangement is. I won't go into the detail here, although concepts such as majority stakes, which would seem clear, include tests such as dominant influence, which is less clear, I think. And there are also definitions of common purposes and connected persons, which are quite detailed. Again, we may have an acquirer risk here of for example, the Asian National Oil Company. That maybe, if it's, for example, China, that could be a concern. And then finally, in this case, a European company owns a large refinery in the UK and decides to sell a minority interest in the refinery to, again, a range of different buyers. First question, is there a qualifying entity? Well, it's carrying on business in the UK, so yes. Acquisition of more than 15%, if it is, there's a mandatory filing. If there's not, well, there might be material influence, say 12%. That's a voluntary notification, and there's risk of the retrospective review. And again, degrees of potential concern about the acquirer risk. Some of these, the US PE-backed company may well not raise any issues. A Chinese PE-backed firm did actually recently. It was Innovation Technologies. And as Jason says, it's not just about the list of infrastructure and technology on the in the consultation document that counts. You could have dual use issues in some of these cases, and AI and the like. But there's one more slide, which is practical considerations. Now, a lot of this will be very familiar in terms of thinking about merger control. There's a significant overlap, but there are differences in relation to process and timing. So what I think comes through strongly is the need for early consideration of these issues, and not just in the UK in terms of potential mandatory filing obligations. The suspension obligation is effectively the same as merger control, i.e. you can't put the transaction into effect until you have it cleared. Otherwise, you risk these very draconian penalties. That will involve conditionality. Gun jumping will be an issue familiar to you, as will the scope of pre-completion obligations. What rights can the acquirer have between signing and completion, for example? How do you allocate the risk of this? Or the risk of remedies, There may need to be hell or high water provisions. That's just a contractual risk allocation matter. Due diligence, what due diligence do you do on previous transactions? Is that 5-year retrospective review going to come back to haunt the buyer? How does this interact with merger control process and timing? That's really just a planning and dealing with the agent sequence. Consultation I've mentioned. Representations to other government bodies. As with merger control, it may well be the case that you want to make representations to various different government departments that might have a voice in this process. And then lastly, there are some pretty broad gateways that allow information to be transferred to other government bodies for similar purposes. So that's really a fairly high-level overview of the new regime. As I say, it's coming, going through Parliament pretty swiftly. So certainly needs to be taken into account as of now in any transaction planning in this sector.
Oh, thank you very much, David. That was great.